Right now, to your top story, the case begins in the Au Pair Affair murder trial today for the defense. Brendan Banfield is the defendant here, and we're going to take a close look at the evidence from the Commonwealth. Did they prove their case? Remember, they've got the burden. We heard a Bloodstain analyst take the stand Monday, her testimony seeming to support their contention that Banfield staged the crime scene to try to frame Joseph Ryan for his wife Christine's murder. Expert testified that there was blood flow on Joseph Ryan's face traveling in different directions. Blood on Joseph Ryan's hands that was transferred there from an object. And blood on Ryan's hands that flowed down toward his elbow, not toward his wrist. So what do you think so far? Has the Commonwealth proven its case? Here to talk about it, let's bring in two people that have a lot of experience prosecuting cases. Current prosecutor Kevin Brackett and retired prosecutor Josh Markey. Good morning to you both. Kevin, I'll begin with you. Your thoughts on whether the Commonwealth has proven the charges they've sought out to prove against Brendan Banfield.
I certainly think they've made a very strong case. You know, a lot's going to turn on how the jury views the testimony of the co-defendant. If they believe her that, you know, this was all a setup and all the other evidence dovetails with what she testified to, I think that they have made a very strong case for guilt here.
Let's take a look at a clip here. I have a clip from Gary Benson. This is going to the bruising and the bloody noses. Here we go.
Remembering Christine's childhood, did you observe any medical symptoms that gave you concern?
Yes, several bruising, bloody noses.
Were they more than the average child's experience?
Yes, yeah, it was a concern to a pediatrician as well.
Okay, Josh Markey, to you next, please. Your thoughts whether the Commonwealth has proven its case?
They've gone a far way, and obviously the evidence of what would have originally been the co-defendant is incredibly powerful. I was watching, and I do think that they may be overlying a little bit on the blood evidence. Juries can get lost in that, and we saw that back in the O.J. Simpson case where there was much more compelling DNA evidence. But frankly, after days and days of testimony, the jury kind of gets lost in it, and the defense exploits that and says, really, is the state just relying on this, and is that the only way to interpret it? And of course, it's not the only way to interpret it.
Right. You talked about the au pair. We got a clip from her. Let's take a look.
He basically said divorce was not an option.
So he didn't want to get divorced. Did he tell you what he wanted to do?
Yes.
What did he say?
He mentioned his plan to get rid of her. He got on top of her, and that's when I first saw him stab her with a knife.
Okay, so we know the au pair testified that he created this plot, participated in it, involved her in it, all of that. But we don't just have her testimony, right? Kevin, we also have other supportive evidence. We've got video evidence. We've got blood stain evidence and spatter evidence. We have other things that the Commonwealth is offering. Do you think that they have told this story in an effective way so that the jury is getting that it's not just the au pair that they need to rely on here?
Yeah, I think the au pair's testimony, Julie, is going to be sort of like the center of it, that the rest of the evidence orbits around. I think that a lot of what the jury's going to have to decide is whether or not all of the evidence sort of is compelling in that it makes sense and corroborates itself. Josh is right. Bloodstain evidence, it can be extremely powerful if it's presented correctly, but it can also be very confusing, and a jury can get lost in the nuances of it and the complexities of blood spatter analysis and interpretation. If it's presented correctly, it can be very compelling and very powerful. A lot's going to come down to what the defense defense is able to put up to establish and undermine the credibility of the co-defendant, attacking her. Obviously, she was facing the same charges that he was, facing the same amount of time. They're going to hammer away at the fact that she has very, very powerful motives to lie, to get some benefit for herself. A lot's going to come down to how effectively the jury is able to exploit that and present that to the jury in a way that makes sense to them and makes them question her credibility.
Right. Great points, Kevin. As you were talking, it got me thinking. We had the blood expert yesterday, and the Commonwealth was trying so hard to get out of her the opinion that Joseph Ryan's body was moved, and she couldn't quite get there. It was a little bit of a clumsy, broad question that she ended on. Defense counsel, he's seasoned, got right up, lodged the objection, and she ended on that objection. Wondering, should they call a crime scene reconstructionist? Josh, do you think they need someone like that in this case?
Well, it would be really helpful. The problem is, and the reason that blood expert was treading so carefully, is there have been a series of cases in the last few years where prosecutors have put on blood spatter type evidence, and frankly, it's not that it's junk science, it's that it's been overvouched, by which I mean, yes, it can help the jury answer questions, but it's not definitive. And I think as I was watching that woman's testimony yesterday, I thought she's being very careful not to say, no, this absolutely definitively proves that. And I think the state, and I agree with my colleague, that what's really going to matter is, do they believe this woman, who was then a 20-year-old au pair, and what is her motivation other than not wanting to go to prison for making up this incredibly elaborate story? Let's not forget that the main defendant was a criminal investigator for the IRS with considerable skills as an investigator.
Right, Josh, great point. Kevin, and to that point, we know the au pair said that he was mindful the whole time through the plotting, planning, scheming that was going on, that he knew an investigation was coming because of his experience, and he knew everything was going to be looked at. Yeah. Looks like he did a pretty good covering his tracks. If he did this, if he was behind it, so much so that his DNA prints not on that knife. Kevin, how big of a deal do you think it is that we've got Joseph Ryan's DNA, we know because he brought the knife, Christine's DNA, presumably because she's fighting against the knife, doesn't want to be stabbed with it, but the defendant's DNA isn't on it. What do you think, Josh? Or excuse me, Kevin, I meant to throw it back to you, Kevin.
That's okay. Yeah, I think, to give the devil his due, it is very a crafty, cunning plan that, if all this is true, to come up with the whole luring him there under the pretext of on the fetish website, all of that, the time that he had to prepare and plan will cut against him as well. I mean, the fact that that evidence is not there is going to be used by the defense, but at the same time, he had time to plan for that, so that can be explained away by the prosecution. I mean, clearly this was well thought out. It wasn't, a spur of the moment, heat of passion, impulse decision. This was an elaborately planned killing.
Right, Kevin. Yeah, it makes you wonder, did he wear gloves if he did this? Did he have time to dispose of them before first responders got there? I think the prosecution, as you said, needs to explain, drive that home, perhaps in close, or if he testifies, cross him on it. We'll see. Kevin Brackett, I know we have to let you go. Thank you for making time for us this morning.